Rico Muhammad, and as you can see, I've already got everybody up and on board. My co-host, Mr. Chuck Snow, and our resident legal expert, Mr. Hank Seaton. Hank is really taking one for the team for us today. Not feeling all that great, and but he's got some important information that he feels like we definitely need to be. It needs to be at the forefront of our radar, and I definitely have with some new developments that have been coming down the pike that I've been hearing about in the industry. I've got a couple of questions I want to bounce off of Hank as well. So, looking forward to having this show. Looking forward to this being very informative as always whenever we have Hank on. So we're not going to belabor the point and stay too long. Just a couple of little housekeeping tidbits before we get started, though, ladies and gentlemen. If you would, please like, share, and subscribe to the channel. You can hit the little bell icon if you're watching us on YouTube. That puts you in the notification whenever we post new content. You will get notified when we post new content first. So that way you will have an opportunity to make sure that you stay on top of whatever it is that we're putting out. And with that being said, let's welcome in my co-host and our resident legal expert, Chuck Snow and Hank Seaton. Good evening, good afternoon, gentlemen. In this case,
Good
how?
afternoon.
Good evening.
Yeah.
So Hank, just to start it off, I'm not sure exactly what you wanted to talk about, but I wanted to pose the question. The independent contractor status is one thing that has come out that I've seen that they've kind of made a decision on. What does that? How is that going to affect uh, things going forward for independent contractors or independent drivers altogether?
Well, the decision of the Department of Labor uh, was not unexpected. What happened was the previous administration put in an economic realities test, which really cut to the chase and said that if you were an independent businessman uh, and had the right to choose, that would be dominant over any other standard. Uh, the new administration, now thankfully 3 years old, uh, immediately said that those rules would not take effect and tried to get the new Department of Labor to come up with different rules. In the heart of this is the fact that the question of what constitutes an independent contractor is a court made decision. And so what DOL was able to do was to uh, say, well, you didn't ask for it, but here's our view of it. And in certain respects, while paying lip service to the traditional test, say, well, maybe an independent contractor can fail one or more of these, and courts you might decision. But they really can't take that ultimate decision out of the court's hands. So I don't think that this decision alone is going to be the death knell of the independent contractor. I think that's uh, just the best that the Department of Labor could do to enforce the union's view of the independent contractor. Uh, at some point, laws give way to politics, and what we're seeing now in the last portion of the Biden administration is their efforts to deliver a whole bunch of things uh, having to do with pro-labor um, agenda, and that's just one. That one doesn't really concern me because you've still got uh, the five-part test that an independent contractor can and should be able to meet. But that includes that you get to choose your routes, rates, and service. You've got skin in the game. It's a 5-point test that uh, uh, we've been able to meet. Uh, what's more concerning in that regard is that uh, we've kind of relied traditionally on the courts, as being the apolitical group, the non-political group that decides things by stare decisis and doesn't get too politically askew. We all know that the Ninth Circuit doesn't play by those rules, and we just have to live with that. But there is a recent decision that is particularly concerning. It comes out of the First Circuit, which is one of those northeastern circuits that's probably got a pro-labor agenda. But it came out with this wonderful new decision that says that the Fair Labor Standards exemption from overtime that applies to drivers who are subject to the hours of service regulation somehow doesn't apply, and that for team operators, you've got to pay the teammate an hour or on a clock that says you got a 40-hour work week, and if you're in the truck more than that, allowing for 6 hours a day to sleep, you get time and a half. So if you follow those things out, you can say, well, gee, you'd be on the overtime clock well into your third day of work. The catastrophic implications of that, if it became a national rule, would be crazy. So, obviously, the intent of it is to say, well, truck driving is a hard job if you're away from home and you can't relax in your stratoliner or whatever it is in your bedroom, or go to a movie, then you should be paid double time. It's a political decision. It's made by the First Circuit. Whether it'll be adopted by other circuits, I don't know. It's well settled that overtime rate doesn't apply. Trucking, you do away with independent contractor status, and everybody's an employee of somebody. You got to wonder how in the world is the one truck, one driver way of life going to work? And it's kind of like we'll have to go back to Pony Express. We're just not changing horses; we're changing drivers every time. So, I mean, I think those are kind of broad-based implications of what's going on in that labor.
Hank, I don't know if you can answer this, but there are other industries besides for trucking where the employees have to sleep at a facility that is provided by the company. I know that in the oil fields and lumber camps, and even up here in Canada, I'm sure they have them in the U.S. We call them snow camps, where the individuals that drive the snow plows, they will sleep in bunkies so they can be ready for inclement weather. I'm wondering how they treat this sleeping time. I doubt they're paying time and a half for sleeping time.
I doubt they are as well. I think the issue is that you're on the clock because you're in the truck, and they're not giving any accountants for the fact that with the in a sleeper operation you got a small apartment. But I would think that this thing would have full application. I don't know how people are treated when they go out on an oil derrick. They probably are. Well, I don't know whether they're flat rated or not.
Yeah, no, I don't know either. But there are other industries where you do sleep, whether you're sleeping while the vehicle is moving or sleeping while it's parked. What difference does it make? You're off duty. And that's part of being in the trucking business. And I don't remember the last time hearing a story where somebody took a gun and said, here, you have to be in the trucking business. You have to be a truck driver and you have to run team. It's people do it because they want to. You make extra money to start with, usually running team.
Well, yeah, and I mean, one way around it is to hire somebody and say, look, we're going to pay you $5 an hour. That becomes $7.50 after 40. I mean, there's all different ways to cut it. I think it's basically if you're paying the man by a job and it's a hard job, how much is he going to make? But that's the difference. That's the luxury that people have who are paying for productivity rather than being on the clock.
Guys, I just want it on record as you're, those listeners that don't know it, I am Canadian. I live up in Canada, but looking over the fence at our good friends in America, I just want to say something. You guys have bigger problems than this you need to address right now. This is craziness.
Yeah. There is. I don't know. I mean, I've lived through a number of different administrations. I've never seen one that is so beholding and so in the pocket of organized labor. Certainly in trucking, their hold on the trucking industry, going back to Jimmy Hoffa's days, was you couldn't get access to what they call closed shops. And you had to negotiate with a favorable union to give your guy a card to get into Kroger. And, I see the return of that. Because in addition to this, there is this other thing. It's called the joint employer status findings. And what it's intended to do is the NLRB ruling that if you are basically, I think, a dedicated carrier, that maybe that manufacturer should include you in his union.
Oh.
I mean, listen, guys, it's not that far. It's not that far removed. For me, I guess it's been back when I was running involved with the company hauling auto parts from Canada. Would you have it down to Tennessee, and we did a hell of a job for Nissan when 9/11 came in. We didn't miss a beat. We just knew how to avoid the scales and go through Sarnia or wherever.
Right.
So I was relaying the stuff at the border, and we were killing a fat hog for Nissan. So I went down to visit Ryder, who was managing the spend at GM, and they said, "Well, welcome, Mr. Seaton. I got two questions. Number one, are you a minority? Number two, are you unionized?" I said, "Neither." They said, "Well, I'm sorry, our hiring won't allow us to use you." And Tennessee is a right to work state.
Right.
Forget all the rest of it. That was the extra thing built into the GM contract.
Wow.
And it shouldn't be lost to everybody that Tennessee, Alabama, Kentucky, all have become the home of the very successful overseas manufacturers. And look at what you got at the big three.
Right.
So somehow it just seems to me as though it's not of ultimate benefit to the country or to people who want to work hard for a living.
No, it's not.
That's very political comments.
Yeah. You know what? It certainly is trying to kill the great American entrepreneurial spirit. And both our countries have been built on entrepreneurial spirits. It's the bedrock.
Yeah, well, I mean, the whole idea of land of opportunity is kind of a sad comment now. All of those folks that are migrating into the U.S., their opportunities probably based upon them being yarded in and not having to report on taxes. I mean, because otherwise, if they get into the system, the idea of not being replaced by robots in the next few years is probably pretty diminishing. We see that with the FMCSA and government. It's all that the way to cut the fat out of the expenses to employ fewer people and mechanize or let technology do what previously required, human intelligence. I don't know.
It's true. And now, on to the next thing. Yesterday was a big day in Washington, D.C. What happened?
Yeah, it's one day. It's one day that I really wish I had been there. Tried like hell to get there, but I had friends who went, and there's some very positive occurrences there. It was broadcast as a listening session on a redo of the new applicant policy. And what the agency did was they put out a suggested new URS, and it was frightening. It was like 25 pages of check the block. You certify that you're familiar with 173 and its application. Check the block. Number two, you certify you're familiar with 273. check the block. And we looked at it. My paralegal, who's been with me for 26 years, went through it, and he said that he did not think that any of the guys filing new application would dare take this on for themselves or understand what it meant. And that what would happen in terms of this thing, if it got passed, was everybody go out and hire somebody to fill out the form, and then they sign it.
This is that 150-page document that they want filled out.
Well, it's not. There's maybe 30 or 40 pages that's documents. The rest of it is an explanation handbook. But here's the thing. There's a lot of good explanation. It's a lot of hard work in it. There's a lot of acknowledgement of things that should be highlighted and administered. The question is, how were they going to use it? And was it going to get at the issue that they candidly acknowledge is there, and that's fraud? The whole purpose of this is to clamp down on fraud. But everybody is leaning on his own understanding. And what was pointed out at the hearing and by a lot of folks is, look, we're glad that you're hearing. We're glad that you recognize that fraud's an issue. We don't see how the dots are connected between signing this application and necessarily identifying the fraudsters. The issues of the fraud really gets down to vetting the new applicant and whether or not he's got a virtual office. Can you go to his terminal and see his trucks? Those kinds of things. And sometimes those things are deceptive. But in any event, the agency really hasn't committed to, at this point, to making readily available accurate documentation on carriers, brokers, and forwarders with email addresses and phone numbers that you can use to verify that the guy you just booked that load with isn't a fraud.
Right.
And that's one of the easiest way to catch these folks. And that is if somebody calls up and says they're a Landstar agent, then by goodness, you need to be able to go to the FMCSA website and get Landstar's phone number and their email address. And you need to be able to send your load confirmation to them with a copy to whoever you booked it with and say, Dear Landstar, I have just booked on your behalf the following load. Please call me immediately if you do not recognize this dispatch. It's become imperative from what I do, that carriers or brokers particularly check out that carrier before dispatch, and that they provide the carrier's name and address to the consignor. And they say, if this dude doesn't show up with the docket number and name on the door, don't tender him the load.
Yeah. Well, you
Now,
know, one of the easiest things that everybody could do that we, when I was with Traffics, it's something I instituted, my God, over 35 years ago, was we had a load number, and we would, every load we had, my God, it was longer than that, over 40 years ago when I think back. And we'd have a load number, which we'd give to the customer and give to the driver. Now, we tried to encourage the customers, please ask for the load number, because we were aware of fraud back then. Fraud's not a new thing in the trucking industry. It's been going around for years, and double brokering. I think it's probably been going around since freight brokering. And just to protect everybody, I would always say, make sure the driver gives you the load number to make sure it was the right driver. And I would, and I always made sure when I gave a load to a driver or dispatcher, make sure you give the shipper this number. They won't load you without it. And
well,
it seems to work.
Unfortunately, the passing down of the load number isn't the kind of verification that, so often a guy will come in and he'll say, I'm here to pick up load number, yada, yada, yada. And they let him in.
Oh, yeah.
Love them.
We've had that happen.
And so often a broker will say, put my name on the bill of lading as the carrier. Well, look, law very simply requires that a carrier doesn't issue a bill of lading, but issues a receipt. And the receipt shows the arch and the destination, the commodity, and obviously the name of the carrier's in possession. Because if you get stopped at a way station, somebody reports that all of those cell phones have been stolen, you need to be able to say, look, here's where he signed the receipt. Here's where he gave me the possession of the goods. It's just like I can't very well get out of Hertz with a car without signing for it.
Right.
Come on, let's just play ball. Well, let me tell you this. You'll love this one. I've got a good client who put in position load integrity protocol I set up for him. And the load confirmation sheet shows is sent to the consignor, and it's sent to the carrier, of course, and it says name of pickup carrier to be verified at point of pickup. Well, listen, he started off by intercepting some yo-yo that tried to pick up a load of distilled spirits going to California. He had a different name on the side of the truck. He barely spoke English, and he said he was going to Chicago.
Right.
Okay? So that was his first idea that this worked. Then a couple of weeks later, he got a load of copper wire. Same thing. So in the past 2 weeks, he's caught 5 guys trying to do the same thing, and it got so frequent that I don't know whether a bunch of them were watching Carrier 411 or what, but they all got together, I guess, and they called him up and said, "Take down the reports on Carrier 411. If you don't, we will shut you down." And he didn't, and he found out how they could try to shut him down.
Wow.
They used hijack. They used enrolling him in everything from A to B and back again. He was literally they retaliated with just a heavy fist. And we unfortunately we live in a country in which nobody will do anything about it.
That's right. That's one of the big issues.
I mean, there's nobody over at FBI who's doing that. It's not like tobacco and firearms. It's not like any other regulated industry.
But there is a law tampering with an interstate shipment. The law is still there. It's just not enforced.
Oh, of course not. And there's also very important Rico laws that apply. And Rico laws are if you're part of a conspiracy and make a misrepresentation with monetary. These things are so easy to make as Rico, and once you make a false application or misrepresentation that gives you access to cargo, opens up the investigation, and then the man with the badge can follow the money.
Right.
Because getting to these frauds, if the guy walks off and Wells Fargo won't is actually laundering the money, and they won't turn it over to civil prosecution, you got to have a man with the badge to go in and get it. And he made out Rico because he could prove the guy fraudulently got the product and was paid. It should be an easy issue, but the government doesn't want to fool with it. They got too many other problems.
Well, because they're majoring on they're really trying to major on the minor things like the AB5, these labor laws, when they should be spending their attention dealing with this, because this is a much bigger problem for the trucking and logistics sectors.
Well, I'm working with a new company, a new group, and they're basically owner operators. It's commercial drivers group, and they're very proactive. They're very much run by kind of a state system,
right?
And they're the first group that I've seen that is not in some sense been more interested in selling goods and services to members than they are in advocacy. These people are really serious about advocacy.
Right.
They're so far I think they're pretty much right on. But small businesses, SBA is there to help. They do as good a job as they can. But the issue is really not made, and it's a very winsome one, that professional truck drivers are people who are hardworking and deserve protection. Can I say?
Yeah.
And they're not looking to the mama state to protect them.
Right. It's a pretty sad state of affairs.
So, Hank, also there's another ruling coming down. I don't know if you want to get into that a little bit or touch on that a little bit. Is the transparency with the brokers having to reveal the how much of their percentages that they're
I was really pleasantly surprised that the agency held that the way that they did. Uh, you know, the real beef that divides TIA and OIDA is this issue. The rules are very clear. The rules are there to create a constructive trust, which is a great remedy to the carrier if it could be enforced. And it's very simply this: if you are a property broker, you're looked at as a real estate agent or as a lawyer. And when you bill for freight charges, you're only billing uh, for or what's your money is only that small
Yeah,
portion of
totally
your
agree.
commission.
Yep.
Okay. And the rules say that you've got to have separate accounting. You got to separate your broker receivables from any other business you're engaged in. So you can't cross collateralize your broker
Right.
operation with your carrier operation. You can't take an egregious salary out. You can't lose money as a trucking operation and subsidize it. And for years, a lot of the unattended fraud was just people who didn't maintain a constructive trust. They didn't set out to be crooks, but they got between a rock and a hard spot, and they had to rob Peter to pay Paul.
Right.
They were just as culpable. Okay, so from my point of view, I was yay raw because when a broker or a forwarder says, you look only to me for payment, I'm not extending credit to him, but I do expect the recourse that if he gets paid, he's going to see that that is earmarked for me. Okay. And that's what gives me the surety to say I should be able to do business with any broker without saying, how deep's are your pocket?
But Hank, let me ask you a question here. I agree with you, but what happens in the case, which happened to us hundreds of times in the 40 odd years I was traffics, where we didn't get paid, customer went bankrupt, and we still paid the carrier. What
That's fine.
happens?
I think that's wonderful. As long as you don't pay him with my money.
Well, no, we always paid everybody, but and one
No,
thing,
no, it's not that you already paid anybody. What I'm saying is, under the laws of the states I practice law in, we've got an IOLTA account,
right?
and that IOLTA account says when I get this great big award I win you, if I'm on 30%, I got to put it in my IOLTA account, and your money goes to you. It's segregated.
Right.
Nobody can come in and attach it. And
I
I applaud anybody who says that. Look, I'll endeavor to pay you if you get hooked and it ain't your fault. Uh, I think that's legit.
But
But
the other thing, what we ran into all the time, especially in lately, before I left, was we a lot of times the carriers would want to be paid right away or within 7 days, or if they're dealing with a factoring company, 14 or 30 days, which we did pay. But the customer, if some of the big ones, and they were the real big American corporations, they were 60 to 90 days to get paid. Well, the carrier's not going to wait 90 days to get paid. That's on me. And you run into that all the time. So it's really hard to maintain that account that way because you're paying off ahead. But I totally agree that is not your money. If you're making, whether it's 12% or 15% or 4%, doesn't matter. That is your money, that 4% or 12%. That's yours. The other belongs to the carrier. I couldn't agree more. But trying to segregate it when the money is going out quicker than it's coming in is sometimes difficult. That's all I'm saying.
well, all I'm saying is, uh, you're making a credit decision to give 60-day terms to the guy who's big. Now, at that point, Do you need a line of credit from the bank so that you can, you can't factor that receivable.
Not,
Uh,
no,
you
we
can't
never did.
factor it, but do you need a line of credit to cover it? Is that going to cost you? I mean, look, these guys that think it's law of the jungle, they think they can just take whatever the terms are. So they give you 60-day terms, and then you have to give 45-day terms
Right,
to Do Truck Charlie, and he's looking at rules that say that he should be paid in 15 days.
right.
If he's an owner operator, he's required to be paid in 15. Being an owner operator who's working for a company that was paying him in 15 days, and now he's got the burden of sifting out the crooked brook,
Yep.
taking the hit. And all of them, it's gotten to the point that somebody in the transaction is paying for the float
Yep.
that the big companies enjoying and paying factoring rates for.
Yeah, I agree.
And increasingly, the load is factored by the broker and factored by the carrier both.
And the factoring companies
Right.
making all the money.
Right.
I have to tell you, Hank, up here in Canada, we only have, I think, 5 big chartered banks. That's all we have in the entire country. And the banks have gotten wise to this, so my banker friends tell me, and they will only give lines of credit to brokers based on the money that should be in their trust account, based on their profit. The banks realized a long time ago this is a flow through. If the carrier is supposed to get $1,000 and the broker's charging $1,200, the bank will give them credit on the $200, not the $1,200.
I understand that, and I'll tell you this: I do enough with factors to tell you that there are some of them that just don't have any kind of sympathy at all for that.
No.
They take the position that when they buy their receivable, it's good as a UCC1. And when the guy that they propped up for so long files bankruptcy and leave, even though they've got 15% holdback or whatever, right, they'll be the first one in the line at the bankruptcy.
Yep.
And that unless the poor carrier who's has got a bond, he never thinks about going to bankruptcy.
Yeah, but you know what? The truth about bonds is, because I found out the hard way when somebody had a bond and they owed our carrier division money. I went after the bond and I attacked the bond, and I think it was through your office's help we did get the money, but it wasn't all of it. Number one. Number two, I think the broker had a large bond, and I think it was about $300,000. But $300,000 doesn't go very far when it was, when this broker went out for a couple of $1 million and owed everybody in town money. So it really, really, the bond doesn't protect everybody. That's part of the problem.
Well, the typical scam.
Yeah.
And I've never gotten anybody at the FMCSA anywhere else to answer for this, is known family fraudster, your friendly West Coast guy. He's got the last name to prove it. 909, third generation. Sets up I love to just use those California names. He sets up a carrier in Rancho Cucamonga the same day he sets up a brokerage in Diamond Bar.
Right.
He gets an authority issued at the same time. Docket numbers are right within one maybe 03 and 104. He runs his scam for 6 months. Neither company has a new carrier audit. He files bankruptcy. 173 carriers file responses. the $75,000 is thrown in by the bondsman and written off as bad business loan, and $1.9 million in unpaid claims.
Whoa.
Jeez.
Wow.
Now look, this guy's a pro at this. This guy is a pro at this. And it traditionally it's just been, where's he going to show up next?
And they know who this person is, and no threat of prison or anything.
Well, who's going to prosecute him? You know,
They hardly prosecute.
yeah, you know, the last time I reported anybody, he called me up and said, "I know where you live." I mean, it's
So here's something else. Just I don't you know, I'm going to throw this at you. I've been hearing, I forget the representative's name, but they're making proponents again to try to raise the minimum insurance for carriers.
oh yeah, I'm covering that this month too. That is some guy that has done that every year for the past heaven knows how long.
He's went from 1 million to 5 million, I think. Is
guys. I just want to say something here. As far as it, I understand both sides, but he's not being realistic on one account, especially to start off. As a new carrier starting out, even if you wanted to try buying $5 million insurance, they will not sell it to you. So does that mean we have no more new carriers? Is that what's going to happen in the United States?
Well, listen, this is somebody who says, look, the cost of medical care has gone up 50% in the past 5 years. Apply that as a multiple. Poor victim deserves to have access to more money. This guy can't add 2 and 2 together. The situation about that ends up being, just think if you said that, look, you know, there are far more people that are killed by 16-year-olds who don't have any driving experience. And if you get hit by a 16-year-old, the chances are you can get 25,000. So, you know, you just very simply can't get that kind of money. And whatever you pass downstream is going to be the minimum demand. If you set it at 5 million, plaintiff's bar will say that stump toe's worth 5 million.
Of course, that's how they work. They look, see how much insurance you have, and if you had 20 million, that stub toe is worth 20 million all of a sudden.
Yeah.
Right.
No, I mean I'm reporting that, and I'm glad you brought it up. I was thinking that it's one of about 12 items that we're reporting on, and I felt like maybe putting down there, don't worry, this guy's tried this every year. But, if you picked it up, maybe I should put a comment in there.
Yeah, I don't know. You know, the thing that my main concern is, you know, especially by me being a small guy, you know, and we talked about this a little bit on the show as well. You know, we're basically pulling for the same rates that we were pulling for 20, 30 years ago. And the cost of everything seems to be going up. I called today, just as an example. I was calling just to price some parts today. I was curious to know how much a clutch would cost for my tractor and how much a turbo would cost, for just to know how much the parts would be. The price that I was quoted from Freightliner for a clutch for my truck, the price was $2,300. Now I remember I used to be able to get a clutch installed, buy the clutch and installed for under that price, and still have a little bit of money to take the mechanic out to lunch if I wanted to.
Yep.
That's just the price of the part. I priced the turbo. turbo is sold separately. You have to have an actuator with the turbo. The price for the turbo is that they quoted me from Freightliner dealership was $7,300 just for the part, just for the turbo, plus the $1,600 for the actuator that you need with the turbo. So you're looking at an $8,900 bill just for parts. We're not even talking about labor or install or any of that stuff. So,
whoa.
And so I'm saying the rising cost of everything that it is to operate your business, but yet and still the money that we are making that to try to keep the doors open continues. Right now, we are under constraints that I haven't seen since I've been operating as an independent owner operator. As short of a while that has been, I've been in business since 2009. So, but you know, it hadn't been I don't have like Chuck. I don't have decades upon decades in, but I'll tell you, this particular point in time in history, this is some of the toughest time in trucking that I've seen.
I just look at the price of new trucks, and it's just astronomical. You know, it's for a plain Jane truck is like a plain Jane Freightliner. No offense against Freightliners,
almost $170,000, $80,000
up here in Canada. It's over. We're talking $225 or something for a plain Jane Freightliner. It's not like and these great big fancy Peterbilts. They're over $300,000. What the hell are you going to haul, man, to pay for $300,000? Like,
you guys will love this. Back in December, we submitted comments to FMCSA's request. They were going to reboot SMS, and they said that the new version was going to rely heavily on technology, and they realized that in order to get enough data to make it work, they'd have to come up with artificial intelligence to write a whole lot more tickets. Okay, so we didn't know how many tickets they're going to write. And, we pointed out that, look, if it's like the SMS, the data sufficiency wasn't the only issue. Accuracy was another, geographical anomalies, and, some dude ain't ever going by a scale and all of that kind of stuff. Well, they must have looked at some of that, I guess, because here, less than a month later, they come out with kind of an oops. It says something like this. Look, we don't want you to add to your comments in December, but we found the following 6 articles that may form some of our views in our notice of proposed rulemaking. And they list these 7 or 8 things. So I run through them and just look at the articles, figuring out that they may give you an idea of what these folks are thinking. And they're all technical articles on the value of putting additional crash warnings on trucks. It's all how you can more laden down trucks with crash avoidance systems. And I got to thinking, so tell me, how is this going to affect the little guy?
Yeah.
Now, if they want those side view mirror things that, I think are very, very helpful, is it going to be 5 extra chromos to the carriers who are buying new equipment and pay a small price for it? Or are they going to dictate retro installing them, and what will that price be?
Yeah.
I mean, it really can't be a battle to see who's got the most technologically strong thing. The poor man can't expect to pay $500,000 for a truck.
Well, right. No.
And you put in all of this, like in California, what the heck are you supposed to do if you got a diesel burning truck?
Well, you know what? That's the law. That's the land of insanity. And I don't know how, I don't know what it is now, but it was the 5th or 6th largest economy in the world. They keep this up, and they're going to be right behind some of the third world countries. They're scaring the hell out of everybody.
I think that
Well, unfortunately, a lot of them are moving here.
Well, yeah, they're moving. You know what? There's a lot of companies and individuals moving into into Tennessee, and there's a lot have gone into Texas and even surrounding states where they're more friendly to business.
yeah, yeah. I think that I don't know. This is a wild, crazy world that we're living in. But before I'm looking at the time, and Hank, I wanted to make sure that we touched on all the subjects that you wanted to touch on while we had you here. Were there anything else or any other news that we need to be aware of before time gets away from us?
Uh, well, we talked about the overtime exemption. I think that's going to be something I'm going to be covering at seminars for people, because no matter whether you're owner operator or not, that's going to affect you. It just seems to me. Let's see what else I've got here.
So the carrier.
I guess the only thing I would say is I've got a company I'm really close with, and they got to up their get their IRP. And all of a sudden, it seems like the states are getting very particular about whether or not they'll file their IRP for you. The state of South Carolina said, and you tell me if you ever heard of this, Rico, that a carrier couldn't buy an IRP for his owner operator.
Couldn't buy a what?
Couldn't put in the IRP.
Oh, it's tags.
Tags. You heard that?
No, I haven't heard that.
Well, so how does that work? How does that work for a company like Landstar, where they put the truck in their name? How would that work there?
Well, the truck's in the name of the owner operator.
Right, but the insurance and the insurance.
Well, that's what I was talking to some gal from South Carolina, because the bulk of the operations out of South Carolina, and Tennessee was saying, "Hey, look, we've got to be able to tie your IRP to at least one truck that's titled in Tennessee, although our principal place of business is in Tennessee." So we said, "Well, hell, we just go switch over to South Carolina. That's the operations hub." And the gal from South Carolina called me and said, "No, you got what have you got? How many owner operators you got to say?" I said 19. And she said, "They'll all have to get their own IRP."
Wow.
Now, as far as I understand it, this company, for all my clients that I've known of, have undertaken to leave the truck titled in the guy's name and pick up the IRP. Does that stump you guys the way it does me?
Yeah, I've never, like, that doesn't work. That would never work.
Right.
The way we do things up here. I know they do them different down there, but still, that doesn't make any sense. And you would think that they would be wanted in the company's name, because now they've got a larger entity that's responsible for the road taxes and fuel taxes.
Well, I mean, you look at it this way, in terms of fraud protection. If I were, if I had some guy who said, prove to me that guy was owned, operated, or leased to you, I'd certainly want to say, well, I bought his damn IRP.
Right.
It's my plates. And South Carolina's telling me no. That just
sounds so backwards. It makes no sense.
Well, Rico, you're quiet on that one. What's your answer?
Yeah, I know. I that's a new one on me as well. But I've always been. I've always come from the standpoint of one of the guys that that taught me when I was coming up. Even if you lease on to somebody, to try at all times to buy your own plates. But I've never heard as far as being a regulation or anything like that where if you were leased on to a company where you couldn't take advantage of them buying the plates for you.
Well, and then I'll tell you another context of that. I've got a client who is a broker. He hired a carrier. The truck driver ran into a building while delivering a load of furniture in Florida. We called up the carrier. Carrier said that the dude was insured with Progressive. Progressive said, dude's not on our list of insured.
Huh?
Yeah, well, Progressive takes this attitude that, although the law requires that they pay for any accident being
Right.
operated under the carrier, that they've got recourse back to their carrier. So what happens is they say that this unit wasn't reported. Now, from my point of view, I told the client, you go back and find the carrier who seems to be a runner at this point, and you tell him that he's personally liable or the company's liable. And I called Progressive and I said, look, I understand you may need to ultimately get your money out of the dude you hired, but I'm going to sue him. And if he don't show up or you don't show up, I'm going to get a default judgment. Then I'm going to present it to you, and you're going to pay me, and then chase him. So I mean, that's the way it plays. It's probably over $10,000. Is it going to be that difficult? But it seems to me that the fact that the guy, the guy list him on the 150, which is where you show what the size of your unit is.
Right.
If you don't have the guy IFTA and IRP, how are you going to prove he's not just some
Right.
Joe Schmo the racket man? You can't look at the side of the truck necessarily. I just can't absorb that. I can't believe that with all the rest the owner operator has to go through. He has to IFTA his own truck, and they're looking at one guy doing the whole thing.
Yeah, it's just
That's interesting.
That makes no sense.
But yeah, I've always came from the standpoint, Hank, that you, especially if you were a person that, when it comes to IFTA, especially, if you drove halfway decently, you got decent fuel mileage. You really didn't want to be on a fleet IFTA account, so to speak, because the fleet's average may be significantly lower than what your average is, and thereby increasing your costs by paying a higher rate.
That's one way of looking at it. I know up here it's a no-go. Everything's got to be like what happens with us when we hire an owner-operator. There's two portions to his ownership. There's the title, which is the truck portion, and there's the plate portion. We have to put the plate portion in the carrier name. And when the plate portion goes in the carrier name, we have to provide insurance for that truck. And then we also have to look after the IFTA that comes onto the carrier, not the owner operator.
One more little quick tidbit on shifting gears before I let you get out of here, Hank. We talked a couple of weeks back on the show as well about these predatory towing practices and stuff of that nature. Is that anything that we talked about, all the different stuff that goes on that Washington should be dealing with or from different municipalities and stuff like that? Is there any type of way of, holding these towing companies to any kind of a standard or some type of recourse? Because it seems like
that is a repeated topic that frustrates us at conventions. It comes up. I just got back from Arizona, down in a snowstorm. There are about 50 of us lawyers meeting, and the whole issue of predatory tow practices came up. And you know, there are efforts in some state legislatures to give you some relief, but it is so spotty. It arises, and you talk about rising costs. A lot of these dudes that are tow trucks are the brother of the sheriff or the county manager or whatever, so they get the first call, and there's no, what they charge is what they charge. I think I may have mentioned it. I think it hadn't been that long I've been on, but we had one out in Wyoming in which the vehicle slid off the road, and they wouldn't turn the product loose. Product was just riding in the vehicle. They had the whole vehicle, but they were going to make us pay ransom to get the product out. And so, in any event, I ended up writing a letter to the state of Wyoming and telling them that it was diversion, and that we didn't know what kind of deal they had got going on with this guy, but that somehow we were protesting it, and they got it released. But the situation was, it was an expedited load, and our consignee was yelling and screaming. And I get that kind of thing when they hold the product hostage, and they don't need that for security. It's just possession's 9/10 of the law.
right.
And then we may run out of time and space here, but I got a guy down here in Tennessee who's in the business of leasing power units, and he leased a power unit to a recommended lessee in New Jersey, and they arranged what percentage of the revenue he was going to get. And he went and got it in Illinois and took it home and was supposed to send the paperwork back and didn't. So after 3 months, my client reported the load as stolen. The state of Connecticut found the crook, arrested him, and put him on the blotter for being tried for theft. Meanwhile, they had some dude come and tow the vehicle. And it was perfectly drivable, but they towed the vehicle to the tow lot.
Right.
Towman is now incorporated 1,700 storage bills.
Oh, yeah.
And he won't turn loose the truck. And the reason he won't turn loose the truck is because he says that we can't prove title. And the reason we can't prove title is because everybody acknowledges that the crook forged my client's name on a new title in Pennsylvania. So the guy's out on bond. The state of Connecticut says that they're going to prosecute him, but he didn't do anything in Connecticut to justify prosecuting. And nobody will tell me how in the devil I get the truck back. From my point of view, the guy's losing money every single day he doesn't have that truck back.
Of course.
And Connecticut may very well decide they want to null pros the guy in December. And so I'm looking for a remedy to get his poor truck back. And there really isn't one. I mean, here in Tennessee, they received what appeared to be, a notice of cancellation. It looked like it was signed by him with a new title issued in Pennsylvania, and it's a fraud. Everybody that's looked at a comparison between my client's signature on the Tennessee title and the signature on the conveying title says this can't be the same person. So I'm trying to find out a remedy. Well, I was at this convention with these client friends of mine in Connecticut, and I said, "Look, is this something you guys can handle?" And they said, "Doesn't have enough zeros."
At least they was honest.
Well, sure. I mean, that's my problem. You know,
Yeah.
here I'm sitting. It's real money to this guy,
Sure
but
it is.
for me to go hire somebody in New York or Pennsylvania up there to litigate it, it's just
It's not worth it.
Jeez.
no. I mean, that's what gives lawyers a bad name. But you talk about the price of everything. Oh, let's face it, guys.
Everything's expensive.
Yeah.
Jeez. Well, Hank, I tell you, we milked you pretty good. We got
We did.
we got more than an hour out of you. So
Thank you so much.
I feel like a milk cow today. Yes. glad you guys enjoyed it.
We appreciate you for taking the time out and struggling through and coming on and explaining and breaking these things down for us. We definitely appreciate it. Thank you again. Get well soon, my friend.
All right.
Hopefully you
wish you good health.
recover and Godspeed on that. And with
All
that
right,
being
guys.
said,
Take care.
absolutely, Hank. And I'm going to give you a call a little bit later too, Hank. I got another question I want to ask you offline.
All right, that'll be great. Take
All
care.
right.
Bye-bye.
Bye.
Thanks,
And so with that being said, ladies and gentlemen, we want to thank you guys, the listeners, for hanging out with us. We definitely appreciate it. You could have been anywhere else in the world, but you took a little time to hang out with us, and we're always eternally grateful for you doing so. With that being said, remember, like, share, and subscribe to the video. And before we jump out of here, I'm going to allow want my co-host to come in and tell us, everybody, if you got questions or any concerns, how you can get in contact with him.
Yeah, if I can help any of our listeners with anything at all, please reach out to me, Chuck Snow 280 at outlook.com. Put your phone number on the email and I'll get right back to you as soon as I see the email, and I'll try to solve your problem. And with that, Rico, I'll let you back her in a hole for another week.
Once again, ladies and gentlemen, I want to thank you again. Stay safe out there. Hopefully you've been able to navigate some of this wintry weather mix that we've been getting hit across the country. Hopefully everybody's staying safe. And as we always say here on the Rates and Lanes podcast, keep it in between the mustard and the mayonnaise. God bless you and good night.
Catch on the flip flop. God bless.